Hi everyone, in this week's video we're going to continue the focus on conduct outside of work and when that can be brought into the workplace and potentially support disciplinary action, possibly dismissal as well. The specific subject this week is the use of social media, and most businesses will have been affected at some point by an employee making personal comments on their own social media pages which potentially have an impact in the workplace. The main area of concern for businesses is conduct that will damage the employer's reputation. And that's why it's quite important to have a policy in place which tries to limit that damage from the outset, such as requiring an employee to set their profiles to private if possible, asking them to make no association with their employer on that page, and regularly checking publicly available content to make sure there's no infringement of those rules. So it is possible, there is case law to support the proposition that conduct which damages the employer's reputation or breaches the employer's policies outside of work can amount to gross misconduct and can support a dismissal, even if it's done in the employee's own time. The key is not to take a disproportionate view of that misconduct, however. If we're talking, for example, about potential damage to reputation, we have to substantiate that, and simply because something has come into the public arena, it doesn't mean that it is actionable. So there's just a few cases I'm going to take you through to bring that to life. The first is Teggett and Teletech UK. In that case, it wasn't actually a reputational issue as such. The employee posted vulgar comments about the suggested promiscuity of a female colleague on his Facebook page. So again, this is his own personal Facebook page. I'm not sure of the privacy settings, but it was obviously brought to the employer's attention. And in this case, the employer linked that conduct to its equality and diversity policies. Again, in your social media policy, you should state that any breach of your internal policies, be that equality and diversity, anti-harassment, data protection, confidentiality, any breach which is serious and which seriously infringes those policies could result in dismissal. And that act on its own, because of the impact that it had on his colleague and because it breached their harassment procedures, was enough to justify a fair dismissal in those circumstances. Trasler and B&Q is the next case, and this is an unfair dismissal. So in this case, the employee was seemingly unhappy about a particular day at work. He went onto Facebook at the end of the day, said that his place of work was beyond an effing joke and that he would soon be doing some busting, which I don't actually know what that means, but I assume it's a derogatory term. A colleague reported that to his employer, who concluded that this was a threat to the business. It was a threat to the relationship between the employer and employee, so a breakdown in trust and confidence, which I know is used quite often in dismissal cases as a bit of a catch-all. But also B&Q said that comment could seriously damage their reputation. The tribunal disagreed. They said that proportionality test was not met. There's nothing to suggest that there would be any damage whatsoever to the reputation of B&Q as a result of that comment being made. However, the employee's compensation was reduced significantly by 50% because his own actions contributed to the dismissal. So even if there is an unfair dismissal, and it should be noted the employer has lost the case at that point, there is a bit of a damage limitation exercise, and the employee couldn't avoid agreeing that those comments had been made, so he did suffer a reduction in his basic and compensatory award. We then go to our penultimate case today, Weeks and Everything Everywhere. The employee repeatedly referred to his workplace as Dante's Inferno on Facebook. He was told to stop doing that. He refused. He said, "No effer can tell me what to do in my personal life." In this case, it was held by the tribunal that the Facebook comments, perhaps because of the longevity, the frequency of those posts being made, was likely to cause damage to the employer's reputation. Very importantly as well, the tribunal attached weight to the fact that the employer had attempted to not conciliate with the employee, but persuade them to take those comments down, and he refused. the claimant also threatened the colleague who'd reported him on Facebook. So all of those things taken together justified that dismissal, and perhaps demonstrates that there's a bit of a higher threshold than the B&Q case when it comes to considering that sanction. And again, it's about substantiating the damage that is caused to the business, to the relationship with the company, and to the relationship with colleagues. Final case is about an employee who posted a video on YouTube. He worked for Summerfield Stores, and he posted a video of an employee in uniform being bashed over the head with a plastic bag full of other plastic bags. In the employer's favour, the employee had a uniform which clearly identified him as an employee of that Summerfield store. But the video had 8 views only. It was taken down 3 days later, and the employee apologised for his error of judgment. So yes, we have probably a fair procedure in dismissing. Yes, we have a fair reason for bringing those proceedings, which is conduct. But in the unfair dismissal test, we then have to consider, is that decision within a range of reasonable responses? Is it a proportionate reaction to dismiss? And in that case, Summerfield were found to have unfairly dismissed the employee. They seemingly took no account of the employee's remorse, the actual impact on the reputation, and other mitigating factors such as the employee's unblemished record and that apology that he made to the company. So in summary, it's absolutely clear that we can bring conduct on social media applications and on the internet into work when considering whether there is damage to the business that justifies action. In all cases, we have to consider the actual impact on the business, or where we're discussing potential reputational damage, we have to be able to justify why that is the case. So we're looking at the potential audience, we're looking at the gravity of the offences, perhaps looking for a frequency or pattern as well. And there may also be policies internally that we can rely on, such as anti-harassment provisions, to justify the very serious sanction of dismissal. If you do need anything on this topic, or indeed anything employment law-wise generally, please do get in touch and email employmenthub@chadlaw.co.uk or visit the website chadwicklawrence.co.uk. Please do connect as well if you want to be first in line to see any more exciting employment law videos. Thank you.